Thanks, Mary, for that very gracious introduction. And thank you for inviting me out to speak on this beautiful fall day. I really commend you for all coming out today on this beautiful day to hear about death and taxes. And that's quite a commitment. But seriously, it's really important topics, and you should commend yourselves for coming out. So I thought I'd just tell you a little story. There was about a grade 5 math class. There was Mrs. Smith, the grade 5 math teacher, and she posed the following problem to one of her classes. A wealthy man dies, and he leaves an estate worth $10 million, and 1/5 is to go to his spouse, 1/5 is to go to his son, 1/6 to his butler, and the rest to charity. And the teacher asked, now, what does each beneficiary get? After a very long silence in the classroom, little Mikey raises his hand, and the teacher says, yes, Mikey, what's the answer? And little Mikey answered, they all get a lawyer. So I'm going to be talking about today sibling estate fights. They're not the only fights or disputes we see in estate litigation, but they certainly are a great majority of them. So I'm going to be talking about what drives them, what causes them, and how to survive them. So here's a Vietnamese proverb. Brothers and sisters are as close as hands and feet. And you got to think about that one a little bit. It could be read a couple ways, but the way I read it is, well, they're related, and they're sort of close, but they're not always on the same page or on the same level. So maybe they're not as close as you think. And then the next quote is from Ambrose Bierce, a writer in the early 1900s. Death is not the end. There remains the litigation over the estate. So these two quotes epitomize the dynamics of sibling estate litigation. I recall speaking at an event where there was approximately 100 people in the audience. And I'm not going to ask you to do this. I know we've been asking this more for a show of hands, but I asked the attendees in that meeting how many had siblings. And, you know, most of the hands went up, almost every hand went up, 100 people. And then I asked, who can't stand their sibling? And I was amazed that 10 hands remained up. It was a public meeting. People were openly admitting that they were having a serious difficulty with a sibling. In my own situation, I remember when I have a sister who's 5 years older than me, and I remember throwing a shoe at her when I was 10 and she was 5 because she was messing with my stuff. You know, she'd get into the game pieces, Monopoly. Ever tried to play Monopoly without the plastic houses? So eventually my dad actually had to give me this big locked cabinet so I could keep the stuff away from my sister. So I wouldn't have to throw shoes at her anymore. And you would think that my sister would forget about that. Well, not a chance. She mentioned it at her wedding about 20 years after the incident when she was 25. So, what happens when we're kids, we don't forget what our siblings did or did not do to us. So in my I hate to say this, 37 years now as a civil litigation lawyer, and for the past several years focusing on estate litigation and restricting my practice to estate disputes, I'm amazed about how often childhood fights or experiences come up in estate disputes. I had a client fighting with his brother because he was left out of the will, and when he came in to meet with me, he was still mourning the fact that his brother had killed his guinea pig when he was 9 years old. Had nothing to do with the estate dispute, but he was trying to tell me how bad a person his brother was, and he related that story. So sibling rivalry is well known. There's a psychologist, Jean Safer. She wrote a book called Cain's Legacy, the Cain and Abel story from the Bible. And she writes in her book that at least 1/3 of adult siblings suffer serious sibling strife. And the numbers rise significantly to 45% when clinicians make deeper inquiries. So serious sibling strife in a great number of families, and this leads to estate fights. So what are the dynamics that are driving these fights between siblings? So scientists have argued that sibling rivalry is in our genes. We're actually hardwired in our DNA for this. And they've looked at various species, going right back to like bacteria, plants, microbes, plants, animals, and they've been able to document and record some pretty brutal examples of sibling rivalry. For example, there are colonies of bacteria that secrete a lethal antibacterial compound which inhibits the growth of their sibling bacteria. In the plant world, there's a species called the Indian rosewood. And this, the first seed of the Indian rosewood secretes a poison which silently kills every one of its pod mates within weeks. Tiger shark embryos have teeth. And the first egg of the shark embryos to hatch feeds on the other eggs with fully functioning teeth so that the largest baby shark survives. Does anybody know what this bird is? Sorry?
I said white.
Yeah, it's a white bird, okay. Actually, it's called a booby bird, and they live in the Galapagos Islands. And there's a variation of this booby bird called the blue-footed booby, and that bird will lay 2 eggs a few days apart. And if the egg doesn't hatch or if the chick dies within a few days of being born, then there's a second egg that can be relied upon. However, there's a problem if both chicks hatch, because in this particular species, there's only enough food for one of them. So what happens if both eggs hatch is that the older chick pecks the other chick to death or pushes it out of the nest, and this is all done in the presence of the mother bird, who does nothing to protect the weaker or second chick. Anybody recognize what this animal is? Sorry?
Coyotes?
Close, no, not coyote. These are hyenas. And newborn spotted hyenas will bite their twin siblings with the result that close to 25% of baby hyenas die of their wounds from sibling fights right at birth. So biologists and psychologists have come up with a theory which they call evolutionary psychology, which maintains that the biological struggle for survival that is observed in the plant and animal kingdom is also being encoded in humans. In his book, Blood and Money, there's an attorney from Michigan, Mark Asatura. He suggests that sibling rivalry, a key component of family inheritance conflicts, can be explained as part of the evolutionary struggle for survival. So as I mentioned before, sibling estate fights have deep roots that go back to childhood. And yes, some of them myself or any other estate litigator who's conducted examinations for discovery, or what you may know as depositions, in a will challenge case, for example. And you will hear stories about a sibling complaining about the behavior of his other sibling when they were young children. And stories about siblings attacking pets, as I alluded to before, are not uncommon. So what is this estate fight? In essence, it's an attempt to resolve unanswered questions and settle some old scores between the siblings. And it appears to me, at least, that a lot of the estate litigation is being driven by a sibling's need to maintain contact with his siblings, no matter how dysfunctional the relationship may be. Unfortunately, I deal with a lot of dysfunctional families. You know, every family has tension between the siblings. Most families, though, can control it. There is a small percentage, and I don't know what it is, but let's say 5%, maybe a little more, that can control it. And it's usually families that have had a lot of problems, or the siblings have not got along as kids, and it carries on into their adulthood. And sometimes I get the impression that, like, I'm sitting there saying, why are you here fighting? You're burning through the money. There's not going to be anything left. I'd rather give it to you, lawyer, than give it what my sibling had. And it's the principle. They'll say it's the principle until they get a couple of my bills, and then they start realizing that principle might be an increased mortgage principle for them to pay the lawyer. So, but really, as I see it, it's their way of keeping a connection with the family. They may have been away from the family for many years, and now when mom or dad dies, they're back in. And they're not maybe being treated the same as the other siblings because they've been away, and this sort of dysfunctional relationship or this argument back and forth is their way of staying in the family. It's very bizarre, but I really believe that's what's happening. Everybody, I guess, remembers the Smothers Brothers show, and Mom Always Liked You Best, a very famous routine. And I remember reading a story where Tommy Smothers was talking about this routine that he did with his brother, Mom Always Liked You Best. And he said the first time they did that routine, the audience went wild when he came out with this line. And his theory was that it resonated with the audience because they all could relate to the experience. It's not fair. Well, that's what little kids always say, you know, when they're not getting like the same size ice cream or piece of cake or whatever. It's not fair, you know. Well, I hear the same thing with adult children in my office. When they get when they're left out of a will or they're receiving a smaller gift than another sibling, it's not fair. So, unfortunately, in Ontario, fairness is not what makes a will valid. I mean, you can have a will that provides unequal gifts or no gifts to children, and fairness doesn't come into play. It's whether or not it's a legally executed will. Did the parent have capacity or testamentary capacity? And I think the first speaker alluded to the test for that. Did they have capacity when they made their will? Was there no undue influence on the part of anyone to have them change their will or make the will that way? So Scott talked about this as well. Sibling estate fights, it's not only about the money. It's about the emotions, and it's about children, both young and adult, competing for the love of their parents. And when a child is not treated equally in a will, it's read as a rejection, that the parent did not love them as much. And also, if there's no heads up that this is in the will, what happens is they're totally shocked and they don't understand why they're not being treated the same, or they're left out, and they often will come to a litigation lawyer like myself, not because they're necessarily going to win the will challenge, but they're looking for answers. Why did mom or dad make the will the way they did? And so, first of all, as I mentioned, it's not about fairness. In certain jurisdictions in Canada, fairness or the moral obligation to treat dependents maybe more equally. In some jurisdictions like British Columbia, the courts have a little more leeway in rewriting wills that we may say, well, they're not really fair. And that's because of their specific legislation in BC. But in Ontario, we don't have legislation in that. So other than certain restrictions that you have to adequately provide for dependents, if they're adult children or spouses and haven't been adequately provided for in a will, they have a right to claim support from the estate. Or other than a married spouse who may have a right to make a claim if they're not given like the entire estate and they feel they're not satisfied, they have a right to make a claim for an equalization payment, much similar to a divorce situation. But other than that, if the testator or the person who's making the will has capacity, it's going to be difficult to argue fairness or moral obligations in Ontario. So that's the principle of testamentary freedom, that it's assumed that everyone has capacity and can leave the estate to whoever or whatever cause that they deem fit, subject to certain public policy considerations. Okay, so if you're going to leave your estate to a neo-Nazi group in order to allow them to fulfill hatred and their propaganda, that gift is probably going to be successively challenged. Or if you leave a gift to a child saying, provided you marry someone within your own faith, that's probably going to be challenged and set aside on the grounds of public policy. But other than that, there's a lot of testamentary freedom. Now, there may be very good reasons why a parent has treated a child differently or unequally in the will. I mentioned before someone coming back after being away for many years. There's a lack of relationship. Whenever I'm consulted or meet with a disgruntled child who's been left out of the will or feels that they haven't got a fair share, I ask about the relationship they had with their parent. And quite often I discover that there's been little or no contact for many years. Maybe a call once or twice a year on Christmas or Mother's Day. And I say to him, well, you surprised that you were left out of the will? You didn't have a relationship with your parent. And that might be a cruel observation, but my role as a lawyer, when I'm meeting with my clients in private, I mean, I don't tell this to the other side, but when I'm meeting with my clients and we have solicitor-client privilege, I mean, I'm not doing my job if I'm not honest with them and say, look, you know, you got an uphill battle here. You were totally out of the family. You had no relationship with your parent, and you know, maybe that's the rationale. So they have to understand, you know, what the problems are up front. Now, it can get complicated if the rift or the lack of the relationship was caused or could be attributed to another sibling. And so we have situations where a sibling might be the power of attorney for personal care, and they're looking after the parent and they're saying they're restricting access to the other child, or they're restricting visits. And while parents have the right to treat their children unequally in a will, there's no question that will increase the chances of an estate dispute after the parent is gone. There's a recent paper published by the Center for Economic Policy Research in the UK, and they observed that unequal bequests are more common than generally recognized, with 1/3 of parents planning to divide their estates unequally among their children. So that's a statistic. As an estate litigator, I'm happy to, as a state litigator, I'm not happy the families are going through this, but so okay, it's more business for me. If families are going to be treating children unequally, there's more work for state litigation. So I used to draft wills. I gave that up several years ago because the state litigation just kept on taking a bigger chunk of my time. You know, we're seeing a tremendous uptick in the state litigation with the demographics and with the money changing hand, and with the baby boomers generation as they're losing their parents, and even as some of the baby boomers are passing on. So also, as Scott alluded to, we don't have the typical nuclear family now. Now you have a lot of blended families. And this study in the UK also found that there's more risk for estate disputes in these blended families. Families with stepchildren, there's not the same connection, even though people say, oh, well, the two families, you know, get along great, but in many cases there is tension, and there is an increased risk for blended families. And also in the situation where parents are remarrying, there's a lot of tension between the children and the second spouse. That is the visceral emotions that we see in this area. So you have to be part psychologist, part social worker, and a lot of our work is, yes, we have to deal with the legal issues, but sometimes we have to actually deal and bring in sometimes even people to help with the emotional side of things. So, like I said before, what's happening in a lot of these cases is not only the fact that they're not being treated equally or getting less, they're looking for answers. Beneficiaries are looking for reasons why my parent did what he did or did not do. So, sometimes we need litigation to commence, because a lot of the answers sometimes can be found in the drafting lawyer's file, in the drafting lawyer's notes. As lawyers drafting wills, they're supposed to keep really good notes. That doesn't always happen, but they also sometimes there'll be answers in medical records or other documents, and you can't get at these documents if you're a beneficiary unless you have a court order. So sometimes we have to start the litigation just to get these documents, and sometimes the documents are enough to satisfy the claimant or the objector that, you know, it is what it is, it's time to move on. Although I very rarely see that happen once the litigation is commenced. So I want to talk about the concept of fairness. And so I want to talk a little bit about, people would say it's unfair. We'll talk about being treated unequally in a will. Okay, I want to give some examples about that. So let's say you have two siblings, and Bob and Sally, and if you leave everything to Sally and nothing to Bob, okay, obviously there's a potential for dispute there. Now the rationale might be Bobby might be a multimillionaire. So the parent says he doesn't need the money, but Sally, she's out of work, she can't support herself, or perhaps she's been dependent on her parents for financial support for most of her adult life, and so Sally will take the position, well, Mom and Dad just want to continue to provide for me. Bobby, you don't need it. You got your millions. Now, even if Bobby acknowledged that fact, that he doesn't need the money, there will still be the potential for a dispute, because Bobby's going to resent that his sister is getting the entire estate. And he'll try to argue, well, Sally could have done more to improve her lot in life. She went to school and she got a PhD in fruit flies and couldn't get a job because nobody's hiring PhDs with fruit flies. So even though Bobby doesn't need the money, there's still a dispute. And I see this all the time. Another common scenario that leads to disputes is where one sibling gets, okay, they're not totally left out, but one gets more than the other. So Tommy gets the mansion and Susie gets the fixer-upper, okay, of the two properties. So it's not it's not the dollars, it's the unequal treatment that drives the dispute. And what also happens is, where the sibling's getting less, now they say, did my brother have something to do with that? So we start getting into questions of undue influence, and they want to attack the will and set it aside. So I just want to talk a little bit what happens if you successfully challenge a will, because a lot of people don't understand. If there are prior wills and you successfully challenge the latest will, what happens is the prior will comes back to life. So if the sibling had a better position in the prior will, they're going to try and knock out the latest will, because they say, well, if I can go back to the earlier will, I'm going to get a better deal. I got one right now where I'm acting for executor. One of the beneficiaries has a bit of a road to travel. They have to knock out 8 wills going back to 1970 before they get a good position. It's not stopping them from carrying on with the litigation. Even though, I think they got a better chance of going to Rama and throwing the dice. The odds are better than winning this case. Doesn't stop them. We talked a little about cottages. The family cottage. That's a topic on its own, and I don't have time to talk about that. But that was one of the reasons why I got out of will drafting, because anytime someone would come in with, I want you to come up with a clause how my kids are going to share the cottage and who's going to have the right to buy and all. I said, I'm sending you to another lawyer. I know he specializes in cottages. But this is also based on a case that I had. Let's say their 2 sons, Sam and Dave, and Dad leaves the cottage to Sam because Dave is the wealthier sibling, and Dave already has a cottage. So Sam doesn't have a cottage, but Dave does. So I'm going to leave the cottage to Sam. And Dad's rationale is he's trying to equalize an imbalance in his children's financial position. But whatever the rationale, rest assured that Dave, the wealthier son, even if his cottage is worth more than the cottage that Sam got in the will, he's going to feel resentment because Sam received the cottage for free. And this, once again, could lead to claims of undue influence. Let's say where there's a family business. Dad and Bob work together in the family business, making widgets. And Sally, the sister, has never been involved in the business. She may receive some salary sometime or some money from time to time, but has nothing to do with the widget business. And so Dad estimates that the business is worth $1 million, and he estimates that he'll give Bob the business worth $1 million, and he'll give Sally $1 million cash to equalize things. It sounds fair. You're getting $1 million business, and you're getting $1 million cash. Fair, right? It's equal. No, because Bob's going to say, wait a minute. It's not a gift. I've been working like 60, 70 hours a week in that business for 30 years. I earned this. It's not a gift. I worked for it. And you're giving my sister a gift? Like she won the lotto? Doesn't work. So Bob is going to resent Sally once again. And to make matters worse, if there hasn't been proper estate planning done, there's going to be a huge tax bill arising out of the disposition of that business. And we don't know yet what's going to happen with the new tax laws with the Liberal budget. I mean, it's being modified every week. But obviously, certain tax advantages to passing on a business, or I'm not an estate planner, but I know that certain. I was at a conference this week when they were talking about certain post-mortem tax planning, like tax planning that you can do after the person has died. Some opportunities are being lost as a result of the law being changed potentially. So, tax disputes or assets that attract tax can cause a problem. The perfect example, and I've seen this done, and it is someone will leave, let's say, their RIF or their RSP, the Registered Retirement Income Fund. Everyone familiar with that concept? You have a Registered Retirement Savings Plan, and then you have to convert it to a RIF when you're 71. So basically, the way it works with a RIF is that when the first spouse dies, there's a rollover, so there's no tax consequence when it goes to the second spouse. But on the second spouse's death, whatever's left in that RIF, so if there's a couple $100,000 left in that RIF, that's going to fall into the income of the deceased estate. Okay, so there's going to be maybe 40–50% tax on that $200,000. So what happens sometimes is in a will, they'll leave the RIF to one beneficiary, and they'll leave some cash to the other beneficiary. But the problem is the RIF attracts a tax liability. And if they don't make it clear in the will that the beneficiary is responsible to pay the tax on the RIF and they get the net amount, guess what? The estate's going to pay the tax. So the person who's saying, wait a minute, my sister just got $200,000 for RIF and I have to pay half of her share of the tax because it's coming out of the estate. Once again, it causes resentment. The spendthrift trial, direct deposit versus a trust fund. So you can have a situation where children are getting the same amount, but they're not getting it at the same time. So there might be two kids, one's very responsible, they're going to get their $100,000 gift or right off, we'll say $1 million, and that the other child, not so responsible, goes through money, likes to go to Casino Ram to gamble. Oh, we're going to put that in a trust, and you're going to get, you're going to be able to get access to it, but you're not going to ever be able to get your hands on it if you need it. And guess what? We're going to make the executor or the trustee of that trust your other brother who just got the $1 million. So there's a fight right there. And I actually had a file where the parents came in and they wanted to leave it in trust to their. Usually, it's like once the kids are 18, they're entitled to their money by law. But quite often, parents will delay that in the will 25 to 30, whatever. I had one once where they delayed it to the son turned 60. So they really didn't trust his financial judgment. So I talked a bit about. Unequal treatment not being fair. What about where you treat everybody equally? You would think that if you treat everybody equally in the will, where's the dispute? Where you get into a problem is, example, if you have a brother and sister and Dick and Jane, and Jane's husband's business, the parents-in-law, Jane's husband's business didn't do very well, and parents floated him a loan or paid off the mortgage on their house that they had put on as collateral for a few $100,000, and then they leave everything to Dick and Jane equally in the will. Well, Dick is going to say, wait a minute, I didn't get bailed out during my lifetime, and you're not treating me equally here. And then you get into dispute over as to whether or not the money that the parents gave to Jane was a gift or was it a loan? Jane's going to say, if there's no documentation, like a promissory note, Jane's going to argue, well, no, it was a gift, you know. And of course, Dick will say, no, it wasn't. It was a loan. So we see a lot of fights over that. Another situation is where one child, and Scott alluded to this, one child becomes the primary caregiver for the parent. Actually, sometimes will move into the parent's home or condo, give up their job. They may say they're not married, or they're divorced and they don't have another, or their kids are grown up, so they're able to move in with mom or dad and look after them. And mom might have said to them, you know, you're taking such great care of me, you know, when I'm gone, you're going to get this condo or you're going to get this house. And then the will is never updated and the estate's divided equally. That caregiver is going to feel, you know, that equal treatment is not fair because they did more and they were promised the house. And sometimes you can go to court over these types of promises, but it's very difficult. The other scenario is where the mom does give the house to the child who looked after her, and then the other siblings say, wait a minute, we didn't know about this, and we feel the mom was tricked into this or was unduly influenced. Now, I've said unduly influenced or undue influence a number of times today, and I really should, I should really talk a little bit about what undue influence is. Undue influence really, according to our courts, means coercion. I mean, like literally getting someone to do something that they don't want to do. Like, you know, if you don't, you know, leave me the condo, I'm going to put you into a retirement home, or, you know, and things like that happen. And it's very hard to prove because it's private, you know, it's not like there's witnesses to it. But, you know, something like, you know, Dad, I would really like that convertible, you know, I mean, you know, remember, you know, I was always your favorite child, and you know, I'm going to get tickets for you to take you to see that show at the Royal Alex or whatever. You know, that might be negotiating, it might be influence, but it's not necessarily undue influence, okay? So kids negotiate with their parents all the time, and it's where you draw the where you've crossed over to undue influences that becomes a legal issue. How am I doing for time? Okay, you'll give me a 5-minute warning? Okay, all right. So, a friend of mine, Les Kotzer, he's written a few books, and he's a will drafting lawyer, but he writes about estate disputes. And he wrote about a case of a woman who had taken care of her mother for many years, and the plan was that she was going to live in her mother's house after her mother died, and would have the right to stay there. But the mother left the house to this woman and her brother, and the brother would not agree to allow his sister to remain in the house. He wanted the house liquidated so he could get his inheritance. And a court case ensued, and in the end the daughter was forced out of the house that she had always been promised would be hers. So the facts in these cases are always going to be in dispute, and the dispute is always, in my view, driven by the siblings' perception of fairness or the lack thereof. So, you know, would it be different if mother had paid salary for services, you know, while she was doing them? Would an equal division of the estate, you know, in that situation be fair? Because you say, look, you got paid for your services. But I've seen these situations in most cases where a child is acting as a caregiver. There's no formal arrangement for remuneration. And quite often the arrangement is very flexible, and rarely is there a contract in place between a parent and child for caregiving. And it's not unusual for the child who is providing the care to have access to the parents' bank accounts. You know, they put them on, either they'll have the PIN code and they get the debit card, or you're going to hear more about this later today, or they're on the account as a joint owner, a co-signer. So I've actually seen cases where the child is given power of attorney to give them control of the money and the parent says to the child, you know, I really appreciate what you're doing. Take whatever you need. You know, here's a blank check. I actually had a case like that. Take whatever you need, and it starts off with, well, you know, I need a couple $100. I need $500. and and then it becomes thousands. So you'll hear more about this today. And then what happens is when parents gone, there's a dispute over what mom really wanted. And I actually had a case where mom had actually written a letter. I want you to know that I said it was okay for your sister to help herself to money, and then there's a dispute. Well, I'm not sure if that's mom's handwriting, or if it's in her handwriting, I don't think it's her words, and someone tricked her into that. It's just a disaster waiting to happen. So even in close families where everyone is hopefully going to be honest and not take advantage of a situation, there is the potential for a problem if there isn't proper record keeping and proper communication. Okay. Because at the end of the day, whoever is looking after the finances, as Doug mentioned, is going to be asked for vouchers, receipts, copies of canceled checks, that sort of thing. There are very onerous obligations in the Ontario legislation, the Substitute Decisions Act, and the regulations to that act for people who are acting as guardians who are or attorneys under powers of attorney. And most people are not aware of what the regulation says as to the kinds of records that are required and the detail of, if you're doing personal care, the detail required of keeping track of medical visits and treatment decisions and that sort of thing. And I think if people really knew what was involved, a lot of them would say they wouldn't want to undertake the task. And I talked a little about gifts versus loans. This is a big area of dispute after the parent's gone, where sometimes the will talk about it, saying, I forgive all loans, and they say, I forgive all loans, maybe it becomes moot. But quite often there's nothing in the will about it. And then the issue becomes, as I said before, what transpired, what transactions, and is there going to be some sort of adjustment made where the kids are sharing the estate? Well, yeah, but you owe us, $200,000. So I've seen some parents keep very good records. They keep a ledger of all loans, but quite often that's not the case. It's not documented. So if anyone's going to make a significant gift to a child, best to get it documented by doing a deed of gift or have a lawyer document it, and talk to the family about it. Here's a situation where you have two siblings, very close, no problems. But soon as there is the potential for, oh, I'm not being treated the same, or it was probably just an instant remark, but I understand because of the work I do, how, if it's not managed properly, can lead to a rift in a family. So I have seen families, God forbid it never happens to mine, but I have seen families where there hasn't been a problem while the parents are alive. But when the referees are gone, when the parents are no longer around, some underlying tension comes to the forefront, comes to the surface. And if it's not managed properly, it can lead to an estate fight. And it leads to an estate fight that people, after a couple of years fighting, they don't even remember what started the fight. And quite often what's driving it is the outlaw or the spouse, the person who's new to the family, or newer, is not the same connection, and that quite often that can be a factor in driving a wedge between siblings. I don't want to talk too much about executor fights because Scott did a great job on that, but executor fights are very big part of my practice. There's resentment if there's, let's say, 3-4 kids and only 1 or 2 of them are appointed executors. The other 2 resent the fact that they weren't appointed as well. And even though I think being an executor, although it's a very important job, it can be a thankless task and it's a lot of work, and there's a lot of potential liability. It's a mistake to appoint all your children as executors, particularly if they don't get along. But I see it all the time. I have one right now, 3 kids, adults, big estate, Dad knew they didn't get along. Somehow they think that if they throw them into this job together, they're going to be forced to get along. It's a recipe for disaster. So if anyone wants to appoint, all their kids, I would say not more than 3 executors, and have the lawyer put a majority rule clause in the will. Otherwise, you need unanimous consent, and if there's a stalemate, nothing happens. You end up going to court, and a trust company or someone has to be appointed as an estate trustee during the litigation to manage the estate. So trust companies are something to think about. A lot of people don't want to spend the money on a trust company. They think they're too expensive, but actually they can be competitive, and if the estate warrants it, and today, with the price of real estate and it's not unusual to see estates now worth, $2, $3, $4 million. If you have a cottage, a house, some bank accounts, some investments, and most of these disputes that we're seeing are like, as what Judge referred to as the one house, one bank account. It's like a house maybe worth $800,000 to $1 million, and a bank account. So it's not a huge estate, but that's the most common estate that you see fights over. And the judges are saying, I had one, it was a larger estate, but the judges are pleading with the parties, for God's sake, settle this case. Don't leave it to a judge to do. I had one case, it was a larger estate. It was probably worth about $10, $12 million, but I remember we were in court on the dispute. There was 4 or 5 lawyers in the court. And some of the beneficiaries are there as well. And the judge turns to the lawyers and says, well, how far apart are the litigants? Like, are we talking hundreds of thousands of dollars apart? Are we millions of dollars apart? And one of the lawyers popped up, oh, no, Your Honor, we're only hundreds of thousands of dollars apart. And the judge turned to the parties and said, well, the lawyers will eat that up soon enough. Just thought I'd show a little cartoon here. I don't know if you can read. It says, next, I remember looking down at my body. Someone's floating above their hospital bed. I remember looking down at my body and my kids fighting over the will. And the next thing I wanted to just show you, that's a quote that I just heard this week, actually, at the Estates conference. It was that, as simple, I love you means more than money, Frank Sinatra. And that's quite often, like I said, what's driving these disputes is, Mom liked you best, or I wasn't as appreciated. So I just want to talk about, we talked about what drives them, these sibling estate fights, so that it's in our DNA. What causes them, the treatment of the different treatment, and even the perceived unfairness in the treatment. So I just want to talk a little bit. Do I have a few minutes? So talk about how to survive these estate disputes. So for the person who, and I've had clients when I was drafting wills. So I know there's going to be a fight, but I'm not going to be around. So my kids will. And I say, and I know when I hear that, there's going to be a problem because obviously. I mean, as parents, we can only do so much to make sure that our kids get along. And I think what happens is, although some parents, some client testators that I've had took some sort of enjoyment or pleasure in seeing this. I had one where the mother clearly would play off one. There were 3 daughters, and she kept on writing new powers of attorney, and she would play off one kid off the other. And obviously that wasn't helpful. But I think more often what happens is, parents can't or don't want to have that difficult conversation. They don't want to sit down and have that dining room chat and talk about the estate plan or why they're making these decisions. And so what we do sometimes is we actually will have a more formal business meeting called like a family conference, where we'll actually try and get all the family to buy into the estate plan and to try to cut off or prevent any estate dispute happening later. So we've seen that done, but not too often. So how to survive an estate litigation dispute? Do you settle or do you sue? Well, usually you start off with a lawsuit, but the vast majority of the lawsuits, 95% plus, never make it all the way to trial. They get settled at some point. So estate litigation, is very expensive, as all litigation is, but it's expensive. It's different from other types of litigation because comes with a great financial expense for the lawyers, and not only lawyers but expert witnesses. Like sometimes we hire psychiatrists to do what we call a retrospective capacity assessment. They'll go through the medical records, the legal notes, to come up with an opinion after the fact, even though they never met the person, as to whether or not they had anything that would have prevented them from having capacity. You might bring in forensic accountants. So there's a lot of expense financially, and there's a tremendous emotional expense. And so I told you about the story about the one with the 3 daughters. That's the one where the hundreds of thousands of dollars quote came out. And estate fights are different from other court fights because in other types of disputes in court, business dispute or whatever, when the case is over, it's over. Parties go their separate ways. But in estate litigation, it's still your family. You can't get rid of them just because you have an estate fight. And there's always the likelihood that they'll meet again somewhere, be it at a family wedding or funeral or some other function. More importantly, the siblings that are fighting, their children are affected. Okay, so you'll have, okay, the siblings, they want to fight, but now their children, who would say, we're close cousins, all of a sudden they become alienated. So kissing cousins become non-speaking cousins. And even though I've had clients say, well, I don't care because I'm never going to have anything to do with that sibling again. And I say, well, never say never, because you never know. You might need a kidney from that sibling one day. And they think about it. And they'll look at me and say, "What do I wouldn't even ask them for a kidney." But you don't know what you would ask for, or God forbid if you were in that situation. Now that's a pretty extreme example, but you really don't know. And all I can say is that at the end of the day, the money that a client may win or receive on a settlement in these types of disputes never makes them happy. Yeah, it's nice to get the money, but I don't know how much happiness it buys. So it's, and I have clients that say to me, well, I want my day in court. Well, you have to understand that you don't just simply walk into a courtroom and get your day in court before a judge. A day in court actually becomes weeks or months in court, and a court case can drag on for years. And many of my clients, after they've been in a fight for a few months, they begin to realize, as the bills are coming in, that they're bleeding not only financially, but they're also bleeding emotionally. It's taking away from their family and their business, their work. They can't sleep. And like I said before, sometimes they forget why they're in the lawsuit. What's the dispute all about? It's sort of like Bleak House. Anyone read the Dickens book Bleak House? Like, just going on forever and nothing left for the beneficiaries. So the estate is, we got a trust company appointed, and every month we're getting the statements from the trust company as to what the fees are, and the estate's is going down and down and down. And they're really fighting over, at the end of the day, there's not going to be anything left to fight. So we were recently in court to set a trial date. And one of the lawyers said, well, we need a 3-week trial, Your Honor. And he says, well, how much is in the estate? He says, well, now all that's left is sort of one asset, and there's a dispute who owns it, but it's worth about $1 million, but it's not in great shape. And the judge said, well, I'm not giving you a 3-week trial of court time for a $1 million dispute. He says, I'm going to give you 2 weeks, and we're going to have a judicial mediation in January to try and settle this case, because you people are crazy. You're wasting the court's time, and you're not doing your clients a service. But it's not the lawyers, in my experience, that are driving these disputes. One thing that I enjoy about my work is that the estate litigation bar in Toronto, where my office is in Markham, but I do a lot of work in Toronto, it's a relatively small number of lawyers that do this work, and for the most part, we're very collaborative and we work well together. And it's not the lawyers, even though people always blame the lawyers, it's not the lawyers, in my view, that are driving these disputes. It's the emotions of the litigants. So I just want to talk a little bit about what our role is. Our role is to give our clients a reality check. and like I said, I've never seen a client be happy at the end of the day of the litigation. And so one of the things that I do in my practice is I've been developing a practice as a mediator. A mediator is a neutral person who helps the parties have a dialogue and tries to get the parties to make a deal. They're not decision-making power. And in Toronto, mediation in estate disputes is mandatory in any kind of estate dispute, and it has a very high rate of success. And so I highly recommend that to anyone who's going through a dispute, is to try mediation or some sort of alternative. Don't leave it up to judges to make the decision, because most judges don't even want to deal with these cases, although we do have a sort of dedicated estates court in Toronto. And you never know, judges are very unpredictable. You never know what's going to happen in court. You might think you have a winning case, and every lawyer can tell you they've had a winning case. They walk in, they lose. They think they have a losing case, they walk in and win. So the best deal is to try to make the deal yourself. So I just want to end off with one quote here: "Estates should be left to loved ones, not to attorneys." So I always encourage my clients to try and sit down and make a deal. A fair settlement is one where nobody's happy. That's why I tell my mediation clients, you got to make compromises. Everybody's going to be somewhat unhappy. And the other thing is, although I don't do the planning, it was alluded to get your estate planning up to date, because that's a big cause of estate disputes, is that I meant to do it, I meant to make these changes, I didn't do it, and then the estate gets left to the lawyers. So I thank you very much for your attention. And if you have any questions, let me know.
We'll have time for 3 questions, if there are any questions.
Yes?
Have you ever had to proceed with a concern around financial abuse?
Have I ever had a case dealing with financial abuse? I certainly have those sort of cases come in. But I have not myself handled, let's say, a claim for financial abuse. Typically, I'll refer them. It depends on the situation. Quite often, the person who's coming for that sort of help is already been, let's say, wiped out financially by someone who's maybe taken money from their account, or they're and it's a very sad situation where they have a right, but it's difficult for them to actually have access to the system. So I refer a lot of those cases there's a center clinic in Toronto called the Advocacy Center for the Elderly, ACE, and they do a lot of that litigation, and clients who don't have funds can sue, and they've had some very good success in getting properties that have been, let's say, titles changed, revert back to the person who lost it. We also get the police involved, but the police this is becoming a huge area now. There's, in terms of the number of complaints they're getting of financial abuse of elders, and you see the commercials on TV all the time where the grandson's going in and helping himself to money, and but there's not enough officers that are dedicated to this area, so they're really undermanned in these areas. And some people say, well, you can contact the public guardian trustee's office, and they're supposed to, it says in the statute, if there's clear abuse, financial abuse, they can investigate. The bottom line is they don't have the resources. They can't keep up with the volume of the claims that come in, so quite often they just cannot be of much assistance. So that's why it's so important to have the family watch what's going on, and I think I don't know if it was Scott or Doug, but one of the previous speakers mentioned about don't have one person doing it on their own. Have a check and balance. That's your best safeguard against financial abuse, I think. Yes.
You mentioned a lot about siblings fighting amongst themselves. What about siblings joining together to fight people who are not necessarily people who had a relationship with the deceased and are being left a part of the estate?
Yes, I've had siblings then sort of dealing with a relative who's got an interest in the estate, being a former employee or friend or an old girlfriend or boyfriend, whatever. Yeah, we certainly are seeing this, particularly when the family doesn't know about it. There was a very famous case in Ontario called Banton. And the Banton case, Mr. Banton was in his 80s and was in this retirement home or nursing home, and one of the caregivers or waitresses, someone who worked there, started up a relationship with him, and unbeknownst to the family, married this person, and the kids didn't know about it. And then they find out about it after the fact. Now, in Ontario, some of the other provinces have changed it, but the wills laws are different in each province. In Ontario, if you have a will and you get married, it revokes your will. And so basically, what happened in this case was he had made a new will, I think, and so the kids took when he died, the kids took this caregiver to court and tried to argue that their father didn't have testimony capacity, therefore the will should be thrown out. And the judge agreed, said, yes, the will is thrown out. But then they had another problem. Did he have the capacity to marry, to enter into a contract of marriage? Well, apparently you don't need much capacity to get married, you know? And the judge said, well, no, he didn't know what he was doing when he made that will, but yeah, he knew enough. He was getting married. He knew what he was doing. And so the marriage was valid. So what happened is the kids thought they would go back to the previous will, but it revoked the will, so the spouse ended up taking a share of the estate, the first $200,000 on an intestacy. That's where there's no will, and they shared the estate with the kids. So there's a situation, there was no marriage contract, so there's a situation where the siblings were getting together to deal with a non-party. So it does happen. Once again, it boils down to did the deceased testator have capacity to make that will? Or were they, you know, if not, you know, that will be challenged, but it's difficult. And what's going to happen is usually you're going to settle with that third person just to make them go away, to end the dispute. One more question? I guess those are the questions. So thank you very much for your attention.